Similarly, under Section 18 of the Limitation Act, an acknowledgement of present subsisting liability made in writing in respect of any right claimed by the opposite party and signed by the party against whom the right is claimed has the effect of commencing of a fresh period of limitation from the date on which the acknowledgement is signed. However, the acknowledgement must be made before the period of limitation expires, as observed above. Section 238A of the IBC makes the provisions of the Limitation Act as far as may be applicable to proceedings before the NCLT and the NCLAT. The IBC does not exclude the application of Section 6 or 14 or 18 or any other provision of the Limitation Act to proceedings under the IBC in the NCLT. All the provisions of the Limitation Act are applicable to proceedings in the NCLT to the extent feasible. We see no reason why Section 14 or 18 of the Limitation Act 1963 should not apply to proceeding under Section 7 or Section 9 of the IBC. Of course, Section 18 of the Limitation Act is not attracted in this case, since the impugned order of the NCLAT does not proceed on the basis of any acknowledgement. Nearer home, in Lakshmi Pat Surayana versus Union Bank of India, a judgment earlier delivered this court after referring to various judgments of this court, including the judgment in Babulal, then held. The report of such observation has been dealt with in the case of Babulal. Suffice it to observe that this court had not ruled out the application of Section 18 of the Limitation Act to the proceedings under the code. If the fact situation of the case so warrants, considering that the purport of Section 238A of the Code as enacted is clarifactory in nature, and being a procedural law had been given retrospective effect, which included application of the provisions of the Limitation Act on case-to-case basis. Indeed, the purport of amendment in the code was not to reopen or revive the time-barred debts under the Limitation Act. At the same time, accrual of fresh period of limitation in terms of Section 18 of the Limitation Act is on its own. Under that Act, it will not be a case of giving new leave to time-barred debts under the existing law. As such, notably, the provisions of Limitation Act have been made applicable to the proceedings under the code as far as may be applicable.